Great. Um, Thanks everyone for coming. This is the penultimate session of the jurisprudence discussion group here in Oxford. We are delighted to have Professor Dimitrios Kyritsis with us today. He's a reader in law at Essex Law School, and he holds an LLB from the University of Athens, and an MJur, MPhil, and DPhil from the University of Oxford. He has published, he's the author of Shared Authority, Courts and Legislators in Legal Theory from Hart 2015, and Where Our Protection Lies, Separation of Powers and Constitutional Review from OUP 2017. And today he's bringing us this very interesting paper, Law in the Service of Legitimacy. So Dimitrios, he will present the paper for 40 minutes or so, and then, as usual, we'll open it up to Q&A. Dimitrios, thank you for coming. The floor is yours.
Thank you, Javier and Philippa and Trenton, for the invitation and for organizing everything. It's always good to be back, as you will have noticed from Javier's kind introduction, I was institutionalized, and it was great back then, and it's great to be back. It's exhilarating as ever, particularly because I want to present the paper I'm going to present today. Is a paper that carries on some themes from the two books, but also perhaps more broadly exemplifies my general approach to doing legal theory, the kind of approach that I picked up while studying here. So. In my work to date, I think it's fair to say that I've been thinking of questions in constitutional theory and the theory of law side by side as communicating vessels. So sometimes I employ insights from the theory of law to make progress with problems of constitutional theory, and sometimes it's the other way around. Constitutional phenomena are used as test cases for claims in the theory of law. For example, in an old paper, I argued that Joseph Raz's theory of authority runs into problems in trying to explain constitutional review of primary legislation. In this paper, I adopt the same method, but with a different aim. I'm not going to offer any new arguments against legal positivism. My claim is intramural. We've got to do this sometimes too, you know. Much as the positivism, anti-positivism debate looms large in our thinking about the nature of law. So I shall assume an anti-positivist framework. It's not the only anti-positivist framework, but it's the one that I'm convinced by, and propose a way of elaborating that framework which I shall claim makes more sense on its own terms. In particular, I shall be assuming the following thesis about the nature of law. First is the idea that the point of law is to justify the use of the coercive force of the state by showing that that use is in accordance with past political decisions. And second is the idea that when a state acts in accordance with past political decisions in the right way, this enhances that state's political legitimacy. I call this the first idea the legality nexus, because it expresses, and it's widely taken to express, an ideal of fidelity to institutional history, which can be thought of as part of the essence of the rule of law. And I call the second idea the legitimacy nexus. Now, I hardly need to point out to this group that the two nexuses didn't just occur to me. They are central planks of Ronald Dworkin's brand of anti-positivism. I'm not sure that Dworkin would be happy with this label, anti-positivism, but I think it's a fair one. Dworkin construes the two nexuses in a certain way, and I will largely be using that construal as a foil for my own proposal, which I will present as an improvement upon or a corrective of Dworkin's theory. Just by way of framing the claim of the paper, the broader questions I will be exploring are, how does law contribute to political legitimacy? How does it help justify the use of state coercion? And how does it achieve that by virtue of its dependence on institutional history? But these are big questions, and there's no way you can address them adequately in one paper. The specific lens through which I will be looking at them is the following. Are legal rights and duties necessarily judicially enforceable? In Justice for Hedgehogs, Dworkin emphatically answered this question in the affirmative. I will argue that there are some legal rights and duties that are judicially unenforceable. Now this may sound as a rather esoteric question of Dworkinian exegesis, of little broader significance, except to Dworkinians. But hear me out. There's more to it than meets the eye. I will suggest that these judicially unenforceable rights and duties that I will be talking about bring into view a dimension of political legitimacy that the law characteristically serves. A dimension of legitimacy that I claim should be counted as part of the moral point of law. I call that the assurance dimension of legitimacy, or assurance legitimacy for short. And assurance legitimacy, just so we have it in a nutshell, prescribes institutional guarantees that a political regime will reliably and systematically act in a morally justified way. I will also claim that some of those institutional guarantees impose constraints on the exercise of public power that are not policed by courts, hence my interest in judicial enforceability. And finally, I will claim that the law serves or enhances, as I will also say at times, assurance legitimacy through its fidelity to past political decisions. Now, just to stem a common misunderstanding based on my experience from presenting this paper before, I do not intend to offer a general theory of judicially unenforceable legal rights and duties. I'm not sure that there is a unified explanation of all unenforceable legal rights and duties. I focus on some judicially unenforceable legal rights and duties because they reveal assurance legitimacy, a dimension of law's moral point that Dworkin, with his insistence on judicial enforceability, has missed. In other words, assurance legitimacy, that would be my claim, explains why there might be some legal rights and duties that are judicially unenforceable, and also explains in what way their existence and content depends on past political decisions. And thus, it too vindicates the legitimacy and legality nexuses, but in a way that departs from Dworkin's account, at least the one that he settled on in Justice for Hedgehogs. Okay, let me start by briefly recapping Dworkin's account of the nature of law, law's integrity. According to law's integrity, the law contributes to political legitimacy because it secures, quote, a kind of equality among citizens, end of quote. That's from Law's Empire. It's the equality we attain when we are all subject to coercion according to the same standards. And arguably, this is relevant for legitimacy. I'm not going to dispute that. In fact, it seems especially relevant that this form of equality is attained despite the fact that we disagree about justice and will therefore take a different view about the moral merit of the applicable standards. Now, how do we know which standards to apply? Well, we look at the institutional record of our political community and we interpret it. We try to identify which principles of political morality best explain and justify it, and then we apply those principles that we've identified in the institutional record to the case at hand. So you can see how law's integrity vindicates both the legitimacy and the legality nexuses. It points to arguably a genuine moral value, a kind of equality. So the kind of moral value that could support the state's moral warrant to use state coercion, and it does so by invoking an idea that makes past political decisions, institutional history relevant. Now, if you're convinced by law as integrity, it would perhaps make sense to also be drawn to judicial enforceability as the litmus test of a standard's legal character. I'm not saying that you would thereby be committed to judicial enforceability. I don't think there's any relationship of entailment between the two ideas. But I can see how one might be taken, the one idea might be taken to lend itself to the other. And here are two reasons. The first reason is because, as Dworkin explained in Justice for Hedgehogs, adjudication bears a special connection with state coercion. Courts are in the business of enforcing certain rights and duties on demand. They direct the executive power of sheriff or police. That's a passage from a phrase from Justice for Hedgehogs. And the adjudicative process that enforces these rights is, quote, directly available to aggrieved individuals, and in the sense that it can be set in motion or on demand. Moreover, adjudicative rights are, quote, immediately enforceable, end of quote. Their enforcement by courts does not depend on further legislative intervention. Now, legislatures have a responsibility to protect rights, certain rights too. The difference between such legislative rights and the adjudicative rights that courts enforce is one of opportunity. Again, that's a turn of phrase from Justice for Hedgehogs. What does Dworkin mean by that? Legislative rights, he says, must wait their turn. In a democracy, the vagaries of politics will determine which legislative rights will be redeemed and when. Now, why is that? Why would that give us an argument to adopt judicial enforceability? Here's a suggestion. When we entrust the protection of a political right to the legislature, we assume that the existence and content of that right still need to be determined through political persuasion and struggle. Accordingly, it's the outcome of that persuasion and struggle that will then mark the community's commitment. Prior to this process of persuasion and struggle, the commitment, if it exists at all, is tentative or not sufficiently determinate. By contrast, again, that's my suggestion. When we demand that a court enforce a right and the court grants that right, the implication is that the community has already committed to it through proper procedures. And because it has already committed to it, we do not need to look to look behind our shoulder to see if our fellow citizens are on board with us. They've already committed to it. We don't need to ask them again. A further reason, and perhaps that's the more straightforward reason for thinking that judicial enforceability tracks the demands of integrity, is that we commonly think of judges as under an institutional duty to decide cases in accordance with pre-existing law. So, if that's their job description, then an integrity tells us to look at past political decisions in order to unearth the principles that explain and justify them. Then it would seem that judges are well equipped to uphold integrity. Now, underlying this picture that I've just described is, I think, a certain understanding of the problem of state coercion, or the moral problem of state coercion. What is it that we are morally concerned about? Well, according to this understanding, what we are concerned about, or should be concerned about, is the point at which a right or duty may be enforced on demand by a court. Now, it's true that this is part of the problem of the moral problem of state coercion. The fact that we can sometimes enlist courts to coerce others is a worrying power, one that calls for moral explanation. But I think the problem of state coercion starts long before the point I've just described. As Nikos Stavropoulos puts it, when we live under a political regime, quote, coercion by appeal to institutions is always on the cards. So, I would say, is the risk that political institutions might decide to use their coercive power wrongly. That's a standing risk. It's a standing risk because it's part and parcel of living in a political community, that we entrust a complex apparatus to govern us, and to govern us through the use of state coercion. And there's an array of institutions that are in the business of coercing. So because it's a standing risk, I would say that it calls for guarantees that I will call systemic, that a political regime must provide ahead of any particular disputes regarding our legal rights and duties. For instance, it must guarantee that there will be judicial institutions as we know them, impartial and professional, in the long run, and that they will not be abolished or staffed with cronies. The point of systemic guarantees, such as judicial independence,
Speaking of...
Sorry for interruption.
So the point of those guarantees is to provide those subject to the coercive force of the state an assurance that the standing power that we give the state will be reliably and systematically used in a morally justified way. Now, I use the idea of assurance, the term assurance, advisedly. I take it from Scanlon's account of due process. For Scanlon, assurance is not a psychological matter. Rather, we can only say that it exists when, quote, there is reason to believe that de facto power will not be exercised in unjustifiable ways. The claim then, my claim, is that the state furnishes such a reason when, or in part, when it has put in place adequate systemic guarantees. Let me say a couple of things about, though not as much as I say in the paper, about how I understand these guarantees. One thing that I want to flag up is that they cannot be ad hoc. The polity must commit to providing them durably, and in a way that makes reneging from them more or less difficult. Unless this is the case, the reasonable thing to do is to free ride or hedge our bets for the possibility that the terms of our submission will change unfavorably along the way. So they must be systemic, they must be provided ahead of any particular disputes, and they must be, to use a term by Larry Sager, they must be obdurate. They must be difficult to renege from them. Obviously, it's common to think of such guarantees, and Scanlon does it as well, to think of the right procedures as furnishing this type of guarantee. But like Scanlon, I think that they're not just procedural. So, for example, the example that he gives, which is very, very pertinent for my purposes, is the example where we have given power to an institution, and then we have given the power to another institution to check that what the first institution is doing is proper. And we have given the second institution the power to make that determination by appeal to certain substantive moral principles. So in this sense, it's not necessarily the case that all we care about is the procedure. Probably it's probably more accurate to say that we care about the procedure and also the moral standards that will govern the second institutions, the reviewing institutions' determination. Now, why do I mention assurance legitimacy? Because I think that it does not figure, at least expressly, in law as integrity. Now, of course, Dworkin says that integrity combines procedural fairness and substantive justice in the right proportion. And perhaps someone could say, well, procedural fairness encompasses also the kinds of principles that flow from assurance legitimacy. So those principles would then belong to the scheme of equal concern and respect that the polity must adhere to over time in order to act with integrity. On this line of thought, integrity would demand, say, that all similar disputes should be adjudicated by impartial tribunals, and also that all citizens should be treated according to the same principles of tort liability that have been applied in the past. I find this solution not convincing. First, I think it's more apt to say that assurance legitimacy operates at a different level from integrity. So integrity identifies a certain principle of political association that political institutions should track, and assurance legitimacy is meant to keep the polity on the straight and narrow so that it will reliably act in accordance with that principle. The second reason why I'm not convinced that we can fold assurance legitimacy within integrity is that assurance legitimacy it does not commit us to court-centrism. The kinds of guarantees that assurance legitimacy prescribes come before adjudication. They are the kinds of principles that we want adjudicative institutions to be governed by, to be organized, according to which they must be organized. So we can't. So there must be something that precedes our the commitment, the court's commitment to integrity, which ensures that those courts are organized in the right way. That idea is captured by assurance legitimacy, but it's an idea or a moral accomplishment that is beyond a court-centric, beyond the purview of a court-centric theory of law. Now, I've talked very in the abstract about assurance legitimacy. Let me just give you a couple of examples to anchor our discussion. In the paper I mentioned two. The first is that the I should have written king. In the paper I say queen. Is the rule that the king or the monarch must appoint as prime minister the leader of the party that commands a majority in parliament, or the rule that says that the U.S. president can only be impeached when certain conditions are satisfied. Now these are really momentous rules, and they're the kinds of rules that we want to see in place in a polity to make sure that people that wield immense power are controlled, but they are not the kinds of rules that are policed and enforced by courts. We want this kind of politically very significant issues to be decided subject to political controls and not judicial controls. Okay, so far I've shown that there is this important principle or dimension of legitimacy. It's assurance legitimacy is a genuine principle of political morality, and I've also said that some of the guarantees that this principle prescribes are not subject to judicial oversight. So we return then to the question with which we started: are there legal duties that are not judicially enforceable? Now, so far, based on what I've said so far, we can't say that they are legal duties. We can perhaps say that they are important moral duties, but we can't yet say that they are legal duties. Our opponent, say Dworkin, might well say, "Oh yeah, of course, it's really important that there's a rule that says that the king must appoint as prime minister the leader of the party that commands an absolute majority in parliament." But this is a political rule. It's not a legal rule. And the strategy that I follow in the paper to establish the legal character of these kinds of rules is the same strategy that Dworkin employed to show that integrity is the moral point of law. So he said integrity upholds legality. It shows why our legal rights and duties should be sensitive to past political decisions, and because this idea, the idea of legality, is so central to our thinking about the point of law. If we do a good job, if integrity does a good job of explaining or vindicating the dependence of our legal rights and duties on past political decisions, then it must be the moral point of law. I will say something similar. I will say that I will try to say in the remaining time that assurance legitimacy also makes some important legal rights and duties sensitive to certain past political decisions, including some judicially unenforceable rights and duties. I should say that it's not just the nature of law that we illuminate through this exercise. It's not just that I will show how the moral point of law must include assurance legitimacy. It's also the idea of legality it's also the idea of legality that I think it's also our understanding of the idea of legality that we make progress with, and this is just as it should be, right? Dworkin famously said that legality is a controversial idea, and there are different conceptions of legality. By showing how assurance legitimacy vindicates legality, we also show what it is that we care about when we care about legality or the rule of law. So there are at least two ways in which assurance legitimacy can be said to be connected with past political decisions. As I've said, the systemic guarantees that we typically associate with assurance legitimacy have to do with procedures. So in as much as a political decision follows those procedures, it satisfies the conditions of assurance legitimacy and can rightly command the allegiance of legal subjects, at least pro tanto. Hence, as per the legality nexus, the rights and duties that flow from this political decision can license the use of state coercion. But obviously that's not enough. Not just any good procedure contributes to the content of the law of a particular jurisdiction. It is a desideratum of theories of political legitimacy that they make obligations of legitimacy, political obligations, particular, in the sense that they attach to a certain polity. The French Parliament may have impeccable procedures, but it would be an embarrassment for a theory of legitimacy if it entailed that the French Parliament's decisions create obligations for the people of the UK. In addition, a theory of legitimacy must show how it is that the people of the UK are bound by the decisions of the UK Parliament at all, although it is arguably imperfect from the standpoint of assurance legitimacy. And the story that I want to say to meet this desideratum invokes a second connection between assurance legitimacy and past political decisions. This connection can be best illustrated if we cast our eye to the momentous decisions that give rise to constitutional norms. Unsurprisingly, the examples that I gave, the two examples that I gave, are constitutional examples from constitutional law. It is at the constitutional level that the distribution of government power is laid down and the polity's more consequential decision-making processes are designed. Hence, at that level, we will also find an answer to the question whether the French Parliament has any sway over the people of the UK. Now, why is that important for assurance legitimacy? It might explain why obligations are particular, but what's that to do with assurance legitimacy? Well, assurance legitimacy takes a special interest in the answer that we get when we look at a polity's constitution. When, for instance, the constitution distributes government power such that the politically victorious side is subject to controls, it enhances the regime's authority. It gives legal subjects reason to believe that they're not signing a suicide pact by submitting to it. Moreover, constitutional norms enjoy a degree of fixity or imperviousness to change, which, as we've seen, is desirable from the perspective of assurance legitimacy. They stand for a political settlement which is supposed to be long-term and enjoy more or less wide societal support. So for this reason too, it makes sense for this kind of past political decision to have the enduring impact on our legal rights and duties that a constitution typically does. When political decisions further downstream adhere to the constitution, they uphold that political settlement and thereby receive some of the sheen of assurance legitimacy that the constitution secures. In fact, the moral value of this settlement in terms of assurance legitimacy could, on occasion, outweigh some moral imperfections of the procedures that it puts in place. This explains why it is possible that our legal rights and duties are sometimes determined by our less than perfect political procedures. They may be less than perfect, but they embody the political settlement that we've reached, and hence can serve assurance legitimacy. Now I'm running out of time. But I would like to say a couple of things, because I've a couple of things about the last, the penultimate section of the paper. In the penultimate section of the paper, I explain why legality, when seen in the light of assurance legitimacy, does not only focus on procedure, but it would be compatible with a system where the legal character of a standard also depends partly on the moral merit of its content. Now, this is, as you know, is an idea that normative positivists reject. So normative positivists are people that I would otherwise have a lot in common with. They care about legitimacy. They care about attaining legitimacy in the face of disagreement. But they say, and they also care about legality. So they say, in order to attain legitimacy in the face of disagreement, we should stick to past political decisions. But the right way to stick to those past political decisions is by not appealing to the moral merit of the issue that those political decisions have adjudicated on. And this is the bit that I disagree with. And the reason I disagree with is, I give two reasons in the paper. The first reason is that if we care about assurance legitimacy, we shouldn't necessarily always care about certainty or give legal certainty absolute priority. Sometimes we care about making sure that, or making it more likely that our legal rights and duties will be the right legal rights and duties, and perhaps one way to secure that is by having an institution, say the court, rule on the validity of on the legal validity of say a piece of primary legislation on the basis of whether it is in line with certain substantive principles of political morality. In the paper, I say that this might be a good insurance policy to have that that kind of check on past political decisions, on the impact on past political decisions having an impact on our legal rights and duties. The second reason that I give in the paper for resisting the normative positivist understanding of legality is by saying that even if we care about disagreement, even if we care about attaining legitimacy in the face of disagreement, we don't need to embrace the normative positivist response to the problem of disagreement, the pure proceduralist response to the problem of disagreement. A polity can do other things to secure the allegiance, the reasonable allegiance of the citizens who disagree with the content of a policy, of a state policy. For example, it can have procedures that make it realistic that this faction can win next time. Waldron famously defends democracy on the basis that democracy gives, or majoritarianism gives expression to his very demanding notion of political equality, but we might also care for democracy for other reasons, say because it makes political defeat more palatable by holding out the possibility that the political decisions with which we disagree might be reversed if we win next time round. Okay, sorry that I had to go through this last argument quite rapidly. Let me just finish by saying that I have not given any arguments why we should get rid of integrity. I haven't made up my mind whether we should get rid of integrity. Or what I have shown is that it would be sensible to include in our accounts of the moral point of law, it would be sensible for anti-positivists to include in their accounts of the moral point of law assurance legitimacy. And it may well be that assurance legitimacy is one of the principles that form part of the moral point of law, and then integrity is another principle. And we need to somehow find how those two principles interact to see what is the content of the law in this or that jurisdiction. Right. Thank you. Thanks.
Thank you.